balance of probabilities as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail on bond in the context of the four discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offenses unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in view of the drastic step of denial of bond. Wherefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the first. Question B, whether the evidence which was gathered from the first accused's residence located in the Manyora area within Mutahi was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar, in a manner stripping it of the manner of pleading such questions as enunciated in the locus classicus and Arita Karimu case, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a litany of cases. Further, this is a question capable of determination in another forum, separate disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A, that pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B, that the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing two suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C, upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Number 1, that the first accused undertakes not to interfere with witnesses and or evidence. Number 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3. The first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4. That in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5. The first accused undertakes to appear before court as and when required. 1.6. The first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention of hearing unless exempted from attending court physically. 1.7. That in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8, that in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9, is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision that can be read by yourselves. Roman 10, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12, the first accused is warned against offending the sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. B, that the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of bail terms, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be deemed to have complied by doing the following. A, if any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination in chief. B, if any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C, if the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D, the prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E, the prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F, All copies of the tabulated list of witnesses and the state band of documents held by all parties shall be identical to the originals held by the state. Very finally, this matter is allocated to court number 4 for further directions, hearing, and determination. In this connection, there will be a mention before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directions.
Yes, we graciously take your leave, and we want to appreciate your time. Secondly, Your Honor, we pray for summons for the second accused to report to EACC by tomorrow or the day after tomorrow. That is all, Your Honor.
Sorry, let me just take the opportunity to thank you for your patience and being able to produce a very detailed ruling within a very short period of time, which we are obliged about. We are grateful.
I also wish to thank you most profusely. I wish to thank you most profusely for the attention to details that you've given to the matter. I have never any doubt in my mind that you would arrive at the right decision. Two issues which I'll make reference to very briefly, conscious of the fact that I'm sure you're tired, you've spent more time than all of us combined together. Insofar as the office being secure, the office of the distinguished governor, it is our plea that whatever visits that are to be made by the EACC or the investigating team, it is only fair that proper notice are furnished and the counsel for the accused person is also present to avoid a situation whereby is prejudiced by whatever activities that may take place in that office. That is one. Secondly, Your Honor, and I say this with a lot of respect, I do not wish to cause drama. I am at a stage in life and in the profession where I prefer to deal with issues as opposed to drama. There's a lot of police officers who are already outside the court, and there's an indication that there could be an attempt again to rearrest the accused person to defeat the very purpose for which this bill has been granted. Consequently, we would wish to receive an undertaking from the prosecution, just as the undertakings have been made obligatory on the part of the accused person regarding how he is to conduct himself. We would also wish undertaking to be given in front of you that there is no intention at all to again away the accused person and take him to custody to defeat the purpose for which we applied for bail and which you granted orders after very elaborate submissions. And the event they don't give that undertaking, it is our humble plea, Your Honor, because you can't grant orders that are in vain, that you exercise your discretion and extend that day to anticipate rebellion to also cover any intended arrest, if at all. We are giving an undertaking. In fact, I'm giving a personal undertaking as an officer of this court and somebody who has practiced in these courts and also practiced in independent institutions, that if he is required at any given time, we will surrender. Nobody needs to go to knock at his door. Nobody needs to pounce on him as if he's a criminal for him to be brought to court. We'll bring him ourselves.
Thank you, Your Honor. Thank you very much for what you've done today. Is visible in the tenets of justice. In addition to what our lead team leader has said, I would like you to take into account or to give directions to us to the custody of the office of the governor. The custody of the office of the governor should be secure and to be fair on both sides of the coin. Should you make a decision, we would like you to consider that we have a concurrent custody of the office of the governor, so that we do not give any doubts that may lead to the fruits of a poisonous tree, if I may make that in reference to the Miranda case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exaggeration. Thank you, Your Honor.
Your Honor, in relation to the 2 months and the office of the governor, Your Honor, bearing in mind that the governor's office is executed by the governor and the CECs, could you kindly now to give further directions, Your Honor, so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it other than that office is his office. And unless it has a branch, Your Honor, then it means for 2 months the governor is not able to work. And that goes against the Constitution, Your Honor, and against the people of this country. And thank you.
Finally, Your Honor, in respect to the same, permit me to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are in the budget cycle that affects both the national government and the county government.
Sorry. We need to understand if Mr. Njeru is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments post the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clearly so that we prepare, if that's the intention.
We leave it at that. We just restrict ourselves to the issue that I've raised, the 2 issues.
From your side, please, leading.
I'll go